See all
Hello,
of
ma'am.
you. Hi, good
Same here.
afternoon. Mhm. Actually, I'm in the middle of my OPD still, but I told all the patients to थोड़ा देर से आए आज सारे.
Thank you, ma'am. So, with your permission, shall we start now, please?
Yes, please.
Yeah, thank you. Uh, Good afternoon, ladies and gentlemen. One and all present here. I extend a very warm welcome to all the participants to SOCM's virtual talk on surrogacy law and justice. We are here to have some light on the topic of profound significance, the intersection of surrogacy law and justice, to explore its relevance and the social challenges it presents in our rapidly evolving world. As we know that with evolution of civilization, surrogacy has gained prominence as it raised intricacies of legal and ethical questions that challenges to our understanding of the family, reproductive rights, and the pursuit of this justice. Ladies and gentlemen, we have this very important discussion today with the eminent guests and speakers we have. Let me introduce to you our faculty, Dr. Sonia Malikji. She is Director and HOD with Nova Southern Fertility and IVF. Dr. Sonia is Chair for the Advocacy Committee IFS 2018 to date and past Chair of the Infertility Committee. She is the past President of Indian Fertility Society and has chaired as past President of the Indian Menopause Society and has been representing as various international forums, including in Asia, America, and Europe. We welcome you, madam.
Thank you.
Thanks for having you with us this afternoon. And today we have another faculty, Ms. Juhi Arora. She is founder with Juhi Arora and Associates and Advocates with Supreme Court of India. Advocate Juhi is the founder of Juhi Arora and Associate, has been practicing for more than a decade in Supreme Court, Delhi High Court, and various district courts. I will now invite, without taking much time, to our eminent guest, Dr. Sonia Malikji, to take us through your presentation, address the perspective, and enlighten all the audience present here. And if permitted, we would love to share your this presentation and talk with the audience across the social media platforms of ASSOCHAM or maybe on YouTube channel, so that those who are unable to attend right now would be benefited out of your sharing of perspectives. Thank you very much for joining, and I welcome to you, ma'am. Please take us through your presentation.
Thank you so much, Mr. Santosh. Thank you very much. First of all, I am really, really delighted and honored to be a part of this organization. We have heard so much about it, and to actually be a part of it is a great honor for me. Thank you so much for having me here. I won't waste time, like you said, and share my screen as well with you all. Just a second, 1 minute now. Will somebody give me the rights to share this, please?
You have been given rights, ma'am.
I cannot see anything then. 1 second, let me see if I can. Okay. Can you see my screen now? Yeah, I think it is visible. Yeah.
Yes, ma'am. So you can increase the size of your this PPT in full
I have made it slideshow.
Yeah, yeah.
Okay. All right. So basically, we've been asked to talk about surrogacy, and as we all know that this particular act did not come alone. It was in connection or conjunction with the ART bill also, or the ART Act, and as they stand together, because many of the things that have been pointed out in the ART bill are also applicable to the Surrogacy Act. So therefore, I shall be talking about both of them simultaneously, trying to make everybody understand where we are together and where it is separate. So the biggest question now today for all of us doctors is surrogacy. Should we do it or should we not do it? Should we stop doing surrogacy at all, or should we still try to do it? That is the biggest question that is coming to our minds. And we are somewhere like Hamlet, where he was wondering whether he should take his life or he shouldn't take his life. So should we do it? Are we all in the same boat? Let us try and understand what are the problems that this act has, the two acts have in fact raised for us. We all know that the traditional Indian family is not complete without children. That we all know, and many couples face a breakdown in their marriage also because they cannot procreate. And we also know that the inability, I think Juhi will elaborate upon this, has inability of a woman to become a mother could also be the reason for a bigamous marriages or remarriage and abandonment of the spouse and cruelty in the marital family and other forms of domestic violence. We know that the woman is always blamed for not being able to produce a child or an heir for the family. So therefore, surrogacy is a third party reproduction, I would say, is a very good option for people who are having problems in bearing their own children. The treatment comes with several problems in the context of treatments involving third party, because basically these are collaborative treatments and many people are involved in it. And therefore, many times you find that the surrogate did not give away the child to the woman. The relationship between the commissioning couple and the children towards the surrogate also have been difficult. And of course, potential commercialization and exploitation, which has been the prime reason why these acts came about. But then, given that, we should try and understand what actually triggered this and what are the problems that we are facing because of all this. It was, in fact, in the year 2002 that the Supreme Court really legalized this practice in India. And a report from the Confederation of Indian Industry estimates that the practice generates about 2.3 billions a year. It has become a huge, so that Indian surrogacy has become an industry, and so has ART. Instead of being labeled as medicine, we are labeled as industry. So therefore, you can understand the voluminous uh, emphasis it has, and the kind of the foreign exchange that it has been earning for the country. So therefore, basically, people had started coming from other countries also to our country for availing this facility, because it was cheaper in the country. And of course, the medical know-how was at par with the other countries, or at par with the highly developed countries as well. Hence, people were attracted towards India. But then there was an exploitation, and there was huge commercialization of surrogacy. And also, this appeared everywhere. Should we come and rent a room in India? India became tainted because of this, because basically surrogacy was easily and available. Also, the other question that the other reason why this act has come about is social surrogacy for convenience. And we know that these film stars have actually all been using this type of modality to complete their families or to start families. And therefore, somewhere exploitation of surrogates had taken place, which of course was not very well accepted by the government. And hence, there was an amendment in the surrogacy bill in 2010. They started thinking about it, and in 2015, international surrogacy was completely banned. Later, after 2 years of debate, further amendments were made to, and that were kept pending in the parliament. For whatever reason, they could not see the light of the day. And then the bill, of course, imposed a lot of restrictions and punishment on the healthcare providers, but also attempts to regulate the highly fragmented and supposedly unethical surrogacy market that we have. However, finally, because there was so much of back and forth in the surrogacy bill, finally they thought that the ART would not be complete if surrogacy would not be complete if we did not bring amendments in the ART segment completely itself. And hence, both the ART bill and the surrogacy bill came out together. And if we trace this history, we find that subsequently in 2020, the both the bills were somewhere passed by the Rajya Sabha and Lok Sabha. And finally, in December 2021, both the acts were passed and notified in January 2022. Sorry, that should be 2022. So hence, we have disparities and we have similarities in both the bills, but both the bills have to be taken together if we want to understand surrogacy. So now like I said, 2021 and notified in January 2022. The highlight of this present bill is that it is altruistic surrogacy, which is now allowed, and there is a complete ban on commercial surrogacy. Now, there have been lots of remarks and lots of comments on the ban of commercial surrogacy from non-medical people as well. And this is one example where a Rajya Sabha MP from Assam commented that the ban is another example of how out of reach the lawmakers are with ground realities. You say this is an attempt to curb exploitation, but in fact, you're curtailing the rights of women surrogates by removing the commercial component. Is she meant to provide these services free of cost? That is what is a big question that everybody is asking, and whether we are actually thinking that the altruistic surrogacy is really going to be that common and altruistic, and where are we going to get all these altruistic surrogates from. So what are the pros and cons of this? Pros is that the cost is definitely reduced because she is a member of the family or known to the family. Familiarity also, and accessibility as well. However, the cons are strained relationships. Now, you can imagine that many times what happens is, we've already had this as a patient just after this law came into action. A sister-in-law was being forced by the family, the husband's family, to become a surrogate for her sister-in-law. That means nanad ke liye bhabhi. So they were asked. She was being asked and forced to become a surrogate, although she didn't want it. She told us secretly or separately when we were examining her that I'm being forced and I really don't want to go through that. So these things are going to crop up when we are having these. There are less safeguards against this, and of course, cost. Although we are saying pros that the cost is less, but there are going to be hidden costs which are going to come up, and I shall elaborate on that, and maybe Juhi will also do that. So what is there for what is the confusion, and what is it for all of us, for those who are offering these treatments, for every couple who is seeking the help of an infertility specialist, and for the general public who are interested in human rights, women's health, and infertility? Should we all not be looking at this aspect of reproduction for both the infertile woman as well as for the surrogate or the donor who is going to be a part of this third party program? So let us look at this, do a SWOT analysis. Let us see what are the various strengths, the weaknesses, the opportunities, and the threats of this particular act or these acts. So the strength, of course, is that there is going to be regulation of ART in India, weeding out of illegal players, and it will definitely stop unscientific and anti-social practices, and there will be better governance. However, what are the weaknesses of the act? There are ambiguities in both the acts. Implementation of the acts is really, really sad, very poor, and of course, it is not patient and doctor friendly. I shall be talking about this. However, what are the opportunities that we have? There will be consolidation of practices because we are trying to weed out the illegal prayers. Then, therefore, we will have more numbers to treat and an opportunity for research and scientific advancement. We see it like that because now it will become more organized. This sector, which had become totally wild as it grew, will become more organized. And then, what are the strengths or what are the threats? The threat is that strict data management, which may go wrong, which we have seen with the PCP and DT Act. For small trivial data errors, doctors have been penalized and have been jailed for such things. Severe punishment on minuscule offenses. Third party reproduction may go right. This is what we are interested in, and this is what we are discussing at the moment. Things may go wrong for third party reproduction as well. And of course, it will be unavailable for those who need it, because we are, on one hand, we are thinking that the cost is going to go down, but no, it may increase in the wrong manner. Hence, these are some of the things that we need to look into with greater detail. So what are the salient features of these two acts? The salient features, how did we want to organize it? What did we do to organize the sector? It was very well thought of because we classified these entities working under the Act into three parts: the ART clinics, the ART banks, and the surrogacy clinics. So, and first of all, there was an absolute differentiation between these people. And then there is a mandatory registration of all with fees and renewal. There is a mandatory staff in each with specific qualifications. No riffraff can do all this now without the specific qualifications that have been laid out by the Act. And then there are defined functions and permissions for enactment of the procedures, which is in great detail and which, of course, can also go wrong. And at the end of it, severe punishment. So all this has basically structured the ART Act and the Surrogacy Act and tried to make it better for all of us to work. However, the process, as I will explain to you, is not without problems. So the act was notified in 22 January. Notification of the act started. There was a promise to form the national and state boards rules and regulations after amendments, notification of the registry and boards, and registration to be applied with payment within 60 days of on the portal after announcement of the authority. And these are the fees that were marked for various types of entities that came up. The ART Bank had to pay 50,000, ART Clinic 50,000, ART Clinic Level 2, which was to do IVF, had to pay 2 lakhs, and Surrogacy Clinic also 2 lakhs. So basically, this is the portal on which you can find all the information that you require on all these acts and where we stand today. And state boards and authorities have primarily been formed in majority of the cases. Delhi, unfortunately, even though it is the capital, the state board has been uh, actually notified to us, but not functional. As such, we have not had any registration in any of our clinics. The clinics have still not been registered, and there is no registry as such. So in 2005, ICMR also tried to do something to something to this ART segment, and they also said that there should be formation of boards and national registry, and they classified the ART clinics into three parts. That means the primary level clinics with diagnostics and basic treatment, secondary level 2 clinics diagnostic treatment up to IUI and IUI donor, and tertiary level 3 clinics for IVF. So there were three types over there, and there were no ART banks and surrogacy clinics. However, in this new guideline, what has happened is that we have the formation of ART and surrogacy boards, the state boards for ART and surrogacy, and then, of course, the registration authority, which I said is still lacking in some of the states. So then, like I said earlier also, these are the fragmentation. This is what it is now. We have all these three types of entities, and this is what we will have to see what is doing what. Now, here I said that the surrogacy clinic has to give 2 lakhs, and the level 2 clinic also 2 lakh. And the registration of these clinics is 5 years, whereas the surrogacy clinic has to register every 3 years. And a monthly report of all the data has to be sent to the appropriate authority or board each month, which is still pending, which has not yet started. However, let me describe what is the function of these ART clinics. The level 1 ART clinic would be clinics where only the preliminary investigations are carried out, including the diagnosis, type of infertility, and IUI. And in level 2 clinics, in addition to all that, we are also allowed to do therapeutic procedures of IVF or ART. And also, such clinics will also undertake surrogacy if they have registered in that. So in order to have a surrogacy clinic, you will also be a level 2 ART clinic, and you will be a surrogacy clinic. You will have to take registration like that. Now, for the level 2 clinics, it is very important because these are the ones where you are going to do everything: surgical retrieval of gametes, handling of the eggs outside the human body, fertilization of the eggs, then transfer of the embryo into the reproductive system of the woman, and carrying out the storage of gametes and embryos to perform any kind of procedure later on. So these clinics are also allowed to carry out research. And actually, now what is the other limiting thing in the new act is that the shifting of gametes will only be allowed with the permission of the board. So for instance, I have a patient who has who has got her eggs frozen with me today because she had cancer when she was a young girl, and now she has eggs frozen with me, and now she's got married and wants to get embryos formed out of that. She will have to take the permission of the board, state board, first national board, then state board, in order to shift that. Now, if she is not in Delhi and she's in Bangalore, so in order to shift the eggs from Delhi to Bangalore, she will have to take these permissions. And that actually, at the moment, when we were talking to the government about these laws, we did tell them that this is going to be very difficult later on, because we know how government processes act, and this is going to cause a lot of delay. But we were promised that it is not going to be such. However, today we are seeing the same thing happening. We have been trying to get embryos within, say, one district of Delhi to another, and that is also taking a very, very long time. It is not happening. Similarly, posthumous storage of gametes is now allowed after prior consent of the dying patient and permission of the board. But the gamete, and basically you would have to have a consent of the dying patient as to where the sperm or the egg of this person is going to go after they pass away, because lots of patients who have cancer are freezing their gametes now with IVF centers. Gametes and embryos may be destroyed on non-payment of renewal of fees if the patient does not respond beyond two reminders. This is something which has come up, and this is very important because basically our labs are flooded with gametes and embryos with nobody taking nobody taking responsibility for them, and we are writing after letter to them with no response. So we cannot even destroy them, and now we can if we have written to them twice. So these are the mandatory staff that you require. I will skip this because we have non-medical people over here. I won't go into the detail of this. This is very important because basically those of you who, and especially since I have lawyers here with me, the definition of a gynecologist initially was the same as that is found in the PCPNDT Act. However, in June, when the act was revised, when the amendment came and the rules were passed out, then the definition of a gynecologist has changed dramatically, and now only a medical postgraduate in gynae and obstetric with a record of performing 50 oocyte retrievals under the supervision of a trained ART specialist, or with 3 years of training in a registered ART center, or with super specialist DM fellowship in reproductive medicine, or experience of not less than 3 years in reproductive medicine. So this is the kind of person who is allowed now to practice IVF. Other doctors, other gynecologists who do not have this qualification will not be able to practice IVF or surrogacy. So that is very, very clear. It has become a very super specialized field, which is a good thing because it will definitely tell people where to go and where not to go. Embryologist also, same way, has to be a very specialized, and these are the qualifications for the embryologist. In addition to that, you have a counselor, you have to have an anesthetist and a director who is responsible for the day-to-day activities of the clinics. ART banks are also specific, and their registration fees is 50,000. They are responsible for screening, collection, and registration of donors, semen donors, and cryopreservation of sperm. However, for the woman, they will only be screening the donor and registering the oocyte donor. Collection of the oocytes and storage will not happen in the bank. It is to happen in the clinics where the oocyte collection takes place. So therefore, you can operate as a semen bank, or you can operate as an oocyte bank, or you can operate as both. Now, most importantly, the maintenance of the records or data of all the donors have to be regularly sent to the National Registry, which is not existent at the moment. So therefore, even the ART banks have not yet been registered, especially in the state of Delhi. No bank has been registered, but many people have already applied for registration, but yet everything is still pending. So basically, the other important thing in this act, which is a good thing, of course, but it will also have negative repercussions, is the grievance redressal. Every clinic and every bank will maintain a cell in respect of matters relating to such clinics and bank, and the manner of making a complaint before the grievance cell has been specified in the Act in Form 5. Now they have given the manner, but they have not said who is going to be a part of this grievance redressal cell in every clinic. But yes, it has been made mandatory that you will have somebody who will look at the grievances of the patients. So therefore, registration of clinics and bank, mandatory requirements, and selection of cycles for donors, for self and donor according to the law. This is the summary of the acts. Now, what are the mandatory requirements that we are talking about? If it is a self cycle, you have to look at the age of the couple, the marital status, proper consents, data entry, storage of gametes and embryos for not more than 10 years. Who are not allowed in self cycles? Single man and same sex couples. They are not allowed to undergo any IVF, any treatment, whether it is whether it is surrogacy or whether it is donor cycle or whatever. Single men and same sex couples have been barred. Donor cycle, on the other hand, you have to have a specific age of the recipient and donor. The sex and marital status of the recipient is important because, like I said, it cannot be same sex couples. One donor per couple once in a lifetime is what is important, and it can be a known or unknown donor, but it must be routed through the ART bank. Insurance for any complication arising out of the procedure is important. An affidavit from a judicial magistrate is also required. Similarly, proper consents and data entry and storage of excess gametes or embryos of the couple for not more than 10 years in case of a donor cycle. And when we talk of surrogacy, it is 25 years. So, sorry, storage is 10 years, but the record keeping is for 25 years. Now, we are very specific now of age. Age has something which is good that has come up in this act, because we know that lots of old age couples have been made mothers. In fact, India had become famous for making grandmothers mothers. So that stigma will probably now go away, because there is a specific age fixed for everybody. In self cycles, it is from 21 to 50 years, and in the male, it is 21 to 55 years. In the donor cycles, the female is between 23 to 35 years and the male between 21 to 55 years. Now, why is there this difference? Because they say that, you have, when you get married at the age of 18, you must wait for at least 5 years before you can resort to any of these cycles. So here again, the recipient female is 23 to 50 years. If you have to do a surrogate cycle, male is 26 to 55 years, keeping in mind that the age of marriage is 18 and plus. An intending woman who wants to use this kind of a facility of a surrogate, a single woman who is divorced or widowed, can also use surrogacy, can use a surrogate to have a child, and her age should not be between 35 and 45 years of age. The surrogate, on the other hand, has to be between 25 to 35 years of age. So this age has become very, very important, and all of us have to really stick to it, looking at the Aadhaar card, which is actually the proof of age in these patients. So I will do this. Now, coming specifically to surrogacy, surrogacy clinic means a center or laboratory which is conducting these technological services and IVF services, genetic counseling center, genetic laboratory, assisted reproductive, anything wherein a surrogacy procedure is conducted, or anything related to that is conducted, is called a surrogate clinic. Now, every surrogacy clinic has to register within 60 days of the appointment of the appropriate authority. They have to apply for registration, and any clinic who is already now you doing surrogacy should stop doing it unless that clinic is registered. So as of now, surrogacy was stopped for some time till the registration fees was deposited. So it will be deposited under the authority. I'm not going to the detail of this. Most importantly, license is to be renewed every 3 years. And like I said, the records and charts and everything have to be kept for 25 years. So it's a long time that you have to do it. Implementation of the act is, like I said, full of hiccups, and there are lots of differences. Now, altruistic surrogacy is something that we have now come to understand, where we are not going to pay any fees or remuneration or monetary incentive to the woman, except her medical expenses and the loss of service if she is working somewhere. So it has not been defined in the act or rules as to who can be a surrogate. Further clarification is required, because somewhere it is mentioned that she should be genetically related to the recipient, which is no longer there. So therefore, that confusion is still going on. And then, basically, who can avail surrogacy? A heterosexual couple who has been married for 5 years, between age 18 and 21 years for the man. So therefore, I spoke on this. Widowed and divorced single woman between ages 35 to 45. LGBTQ and single men are denied surrogacy, and couples of Indian origin, OCI, are now allowed, but foreign citizens are not. This is a recent change, and this is a welcome change as well. So basically, this has also gone under a lot of criticism, wherein they have said that why should same-sex community be not allowed to go in for this kind of a thing, because this is allowed in many countries. So now coming to the various difficult situations that we have because of these. Something called the essentiality certificate. I think I'll leave that to you, Juhi, because these are all legal things. You probably will have to clear this up as to these are the indications that are written in the act, where these have to be present in order to say that this person qualifies for a surrogacy cycle. So before you embark on doing anything to even look at a surrogate, you must have any of these conditions. It is not just for fun that you can take a surrogate and do a surrogacy cycle like some of our film stars did, but there has to be a real valid medical reason for you to do a surrogacy cycle. Now, this is one clause I wanted to highlight very much. This, it is written over here, they should not have a surviving child biologically or through adoption or through a surrogacy earlier. That means if you have one child by any means, then you're not capable, then you're not eligible for surrogacy. Now, this is actually against the tagline that the government uses, "Hum do, hamare do." If the fertile people are allowed to have two children, why should not these couples who are not capable to have their own child have another child if they have one child? The only condition where they can really have another child is when the child is mentally retarded or something. So this is one thing which needs to be really paid attention to. Then, of course, the second thing is that you have to take a certificate from the board again, that you have to take it from the court, actually, from the magistrate, that the child that is going to be born out of this arrangement belongs to the commissioning couple. So that affidavit has to be taken first before you embark upon surrogacy. And then there are the indications as to who can be a surrogate. So basically, these are some of the points that have been written over there. But the actually contention, and these are the documents which are required: written consent from the surrogate mother, fitness certificate from the bank as after screening, a fitness certificate from the appropriate authority, an insurance cover from the insurance agency who are under the Insurance Regulatory Act. So these are some of the documents. It is a very long drawn process. And then basically these are what you are requiring. So they have to say that they are not going to use this child for any kind of commercial activity, not going to sell the child, and not used for prostitution, etc. So, therefore, there are lots of permissions which are going to be required from the board: essentiality certificate, eligibility certificate, certificate of belonging of the newborn, and for the surrogate, again, a medical fitness and an affidavit of willingness for altruistic surrogacy. Maybe I've missed out something, maybe Juhi will tell you more. So, lots of offenses are also there laid out in the Act, and sex selection is one. And there are other offenses which I'm leaving to her to tell you, because these are so many, and very, very harsh punishment has been laid down for anybody who is doing breaking this law. And so the punishment is not less than 5 lakhs and can extend to 10 lakh rupees. And again, the jail term may be not less than 3 years, but it can extend to 8 years, with a fine which may not be less than 10 lakh rupees, but can also extend to 20 lakh rupees. So basically, you can see that the punishment for this is very, very harsh, and hence nobody can dare to do anything wrong over here. So a jail term of 10 years and a 10 lakh rupee fine for the practice of surrogacy if you're caught doing commercial surrogacy, or if there is an abandonment or exploitation of the child, or exploitation of the surrogate mother, or for sale, import, and trade of human embryos, etc., etc. So this is something which is extremely, extremely difficult. But of course, yes, it means that you have to stay well within the law. We shall talk. But the good part is that in the miscellaneous chapter 6, there is a power to remove these difficulties, and with the help of basically approaching the government, or putting up these RTIs and telling them that these are some things that we need to do. The It has to be done. You have to make complaints within 3 years of the commencement of the act, and as you can know, already a year has passed. So therefore, these have to be really seriously thought of and complain to the department. Again, for the surrogacy also, instead of 3 years, you have to complain within a period of 2 years if you want anything in the Surrogacy Act to be changed. So therefore, one really has to be very careful and start doing proactively. So I come back to this slide again, and let me see again the threats and the weaknesses. These were the two things that we have in front of us, and I'm just going to present a couple of cases. What are the threats and weaknesses? A lady, 36 years, with a history of cancer of the uterus, and has had removal of the uterus at 34 years. Now, she doesn't have a uterus, so she needs a surrogacy. She gets married at 35 and has been told that her ovaries are now not responding. She will therefore need donor eggs to have a child. Her husband is 42 years of age, and her sister is ready to become a surrogate. However, she is not eligible for surrogacy since donor eggs are not permitted with surrogacy. What recourse does this couple have now? She has just got married, unfortunate enough to lose her uterus at a young age, and now she's not eligible for surrogacy because she cannot take donor eggs. So the only recourse for her is either to adopt a baby or go abroad where surrogacy with donor eggs is allowed. So that is one of the problems. Second thing is a couple with blindness and the woman has an autoimmune disorder and cannot carry a pregnancy. They approach a surrogacy clinic to be told that they are not eligible because the age of the man is 56 years, a year above the age limit, even though they do qualify as per the essentiality certificate. So even a 1 year respite is not allowed in these patients. A couple within the age limit needs surrogacy because of recurrent pregnancy losses, 10 losses, some early, some late. They get their essentiality certificate from the board. They then take their surrogate, who is the girl's sister in law, as the surrogate, and on submitting the papers, find that she crosses the age limit in 1 month, say June 25, 2023. Hence, is not eligible as the registration process is going to take longer. They have no other person whom they can ask to act as an altruistic surrogate. Now, where does this couple go? Already had 10 losses. Now, this is a very, very pertinent thing which we all must consider. Eligible couple completes all formalities, surrogate is ready, but on the day of embryo transfer, the surrogate refuses to go ahead. And according to the rule 6 Act in the Act 2, notwithstanding anything contained in subsection 1, the surrogate mother shall have an option to withdraw her consent from surrogacy before implantation of the embryo in the womb. That means that the Act allows her to terminate the contract before the transfer of the embryo. Now, what about the formalities? What about all the things that have gone into making the embryos, all that fuss? What will happen to that? Who is going to pay for that? Nothing is mentioned. And on the contrary, rule number 10 in the same chapter says no person, organization, surrogacy clinic, laboratory assist, or clinical establishment of any kind shall force the surrogate mother to abort at any stage of surrogacy except in conditions as may be prescribed. So the commissioning couple has no right to do anything to the surrogate. However, the surrogate can go ahead and refuse whenever she wants to. So this is something which is very lopsided with no sympathy for the actual infertile couple. And again, so basically, then again, 5. I am a registered clinic for surrogacy. Surrogacy has been done successfully. However, it's a twin pregnancy, and on delivering, 2 female babies are born. This is an actual story. Next morning, the commissioning couple, the agent, the surrogate, all disappear, leaving behind the 2 girls. Now, what should the doctor do? What is going to be the fate of these 2 children? So, do you think altruistic surrogacy will prevent these incidents from happening? Do you think this is going to happen? Now, there has been a lot of criticism for altruistic surrogacy by banning commercial surrogacy in favor of altruistic avatar. The identification of close relatives will take on a murky turn, just like in the case of organ donation, where strangers were dressed up as near relatives. In altruistic surrogacy, also similar negotiations may be entered into. In an overtly patriarchal society, women are always at the receiving end of exploitation, just as I told you just now. In facilitating altruistic surrogacy amongst close kin, we may actually be exploiting rather than fostering. So basically, surrogacy bill does not only violate the articles 14 and 21 of the Indian Constitution, it is regressive in nature, also reinforces moralistic notion of purity of the womb and family, and it also takes away the rights and body autonomy of women who might consensuously want to become surrogate mothers. So basically, there are lots of criticisms against this. And yes, this is a film that has been formed, that has been done on the commercial surrogates of Anand. And they also say that the government must understand that they are depriving a living of these people. And we have so many other examples which may not have been right, yet they are still going on. For instance, prostitution. We have not been able to do anything about that. But here, something which is giving a livelihood to these surrogates has been taken away from them. So there are certain points to ponder. Every human is different. Every human has a right to reproduce. In medicine, we are taught individualized or personalized medicine. Each case must be dealt with its own merits and demerits, but remaining within the law. A law made by country is made on the needs of majority and needs to be abided by. However, it should be flexible enough to look at the specific problems of some couples and change accordingly. We are a populous country and we need to control our population, but not at the expense of those who do not have children. We must also remember that the fertility index of the country is on the decline, and if we are not careful, we may have an inverted pyramid of population with the old age people being many and younger generation getting lost. This may make us go the China way, who has recently reversed its one-child policy because of a rapid decline in the birth rate. So, to all of you here who are not doctors or fertility specialists, I, as a fertility specialist, as a representative of the Indian Fertility Society, I would request the authorities to have a more pragmatic and liberal approach towards third party reproduction. Third party reproduction needs to be strictly regulated, not throttled, because it is a need, it's not a luxury. People who need it are asking for it. It's not just that they are wanting to do something fancy. So, with that, I thank you all very much. But we all have to remember to remain ethical, moral, and follow the law while treating these couples. Hopefully, we will not fall into any conflict and punishment then. Thank you so much for being here with me, and thank you very much for giving me this opportunity.
सर यू आर म्यूटेड संतोष जी आप म्यूटेड हैं
Thank you, ma'am. Thank you so much for your kind presentation, sharing your thoughts, perspective, and enlightening all of us. And before I invite Juhi Arora ji, I've asked my colleague Ritima to please have a few questions that she has received directly from the participants and her own from the council side. So she may like to have few questions with you, ma'am.
at the outset at the outset, ma'am, thank you so much for this presentation. It was absolutely very enriching and quite informative. So we have a couple of questions from the participants. So the first question is, I had a query on compensation in ART procedures. Are donors allowed to be compensated, and how much is the compensation, and how is it computed?
Again, it's the same thing applies to the donors as well as the surrogates. They're not allowed any compensation for their services, but of course they just as we are doing it for the surrogates, they are also given money for their travel expenses as well as their loss of work, hours of loss of work, and other medication that they will be receiving. So only that is permitted, and of course there is an insurance over there for them as well, so that if there is any problem, that is covered, and 1 year insurance for any life-threatening complication. All that is given, but yes, as such, no compensation for their services.
Got it. Thank you so much, ma'am. The next question is, if banks are not yet registered, how is the calculation, how is the collection and storage of gametes continuing during this period? Also, can the same company hold clinics as well as banks? Can a bank be situated within the clinic?
Yes, they are actually allowing a bank to be situated in the same premises as the clinic, but as a separate entity, not within the same. Say you have an entrance, one side would be a clinic and the other side would be a bank, but within the same. But of course, under two registrations. One is for the clinic and the other is for the bank. That is one thing. What was the first part that you said? First part of the question?
So the first part was, what if the banks are not yet registered, and how is the collection and storage being continued?
Again, see, just as the clinics are also not yet registered, we have all applied for registration, and the money has also been submitted to the board here in Delhi. But in other states, the registration is complete. The board has, sorry, the clinics have been registered, and the ART banks have also been registered. Particularly in Delhi, it has not yet happened. but in other places it is in place. And so only the registered banks and the registered clinics can operate. Otherwise, you can't. So here we have been told to start operating under this thing garb that we have registered. So those who have not registered are not supposed to be functioning at the moment. Only the ones who have registered, even though the registration has not yet been, the formalities have not yet been completed by the board. Okay, that is the difference. So this is only happening in Delhi and UP. In the other states, boards are in place, registries are in, everything is in place. So they are all proceeding in a normal manner. The banks are also in place.
Very well, ma'am. So the next question is quite interesting. It says, what are the current rules about export and import of embryos to and from India?
Yes, again, I think Juhi will be able to elaborate upon that much better, because basically she is into it much more than me. However, what I have as a doctor, as a clinic, as a person who's functioning in a clinic, what we have to know and what we have to counsel our patients also is that any movement of any gametes, whether it is within the country or it is coming from outside the country, has to be done only with the permission of the board. The national board permits it, and then the application goes to the state board for that. So basically, it's like that. Hence, these permissions are taking a lot of time. I don't think there has been any international gamete transfer from the country or within the country to outside or outside to inside. That probably has not taken place. But yes, within the country, movement has started, because like I said, the other states are functioning fully because they have boards, etc. So therefore, all this is taking place over there, but not international. I don't think, not till now. Before the act came in, it was the ICMR that was giving us permission to move these gametes internationally. Nationally, there was no restriction on movement of gametes till it was being till ICMR was responsible. But international movement was still under the permission of ICMR only and PCPNDT. But otherwise, we could not do that. Now it is the board rather than that.
Noted, noted, ma'am. Um, okay, so can the owner of the bank and the clinic be the same? I think we covered this
Yeah,
question.
that can be same.
Okay, we have a very interesting question. I'll try to rephrase it. So, what is the legitimacy of the second child born out of surrogacy, or if the intended parents are not eligible to become parents through surrogacy, such as LGBTQ or single men who have opted for surrogacy and they already have a child right now?
First of all, LGBTQ are not allowed. They are not eligible. So that is out of the question. We cannot have it. Same sex cannot have a child. Now, if it is a single woman and she has a child already through surrogacy, she has her own child before she divorced or she became a widow. She has one child of her own. She's not eligible for surrogacy. Similarly, if you have a couple who have a child through surrogacy or otherwise naturally also, they are not allowed a second surrogacy cycle. That is unfortunate thing about this act. That's why I said, if we are talking about hum do hamare do, why should we restrict it to only one child in these people? They must also have the same number of children as the others. They should be allowed. I mean, but it is strictly one.
Okay, so the question was like, what is the legitimacy of the child that is already there in place right now through surrogacy?
You mean to say before the act came out? It cannot be, because see, the act, when it came into action, or when it was notified, we were given a deadline of November 2022, that any surrogacy cycles that are going on must finish, the surrogate must deliver by then, because this act was functional from February 22. So if you do the last transfer, embryo transfer, in February, the delivery will take place in November. So after that, nobody is allowed to do surrogacy until and unless you are registered and this law prevails. So that child will definitely not be legitimate. I don't know how they are going to give a birth certificate to that child if it has been born out of surrogacy after November, or after this law has come into place. I do not know how it is going to happen. I think Juhi will probably be able to
Yeah,
help
yeah.
us better, because this is a legal question. Yeah.
Yeah. So we have absolutely a medical question here, which reads: can we do ovarian stimulation for IVF in level 1 clinic and do IVF in level 2?
No. Yes, see, yes, there is a little catch. The definition of ART. ART means assisted reproductive technologies. It is stating that anything which is leading to the handling of gametes, sperm or egg outside the body of the person is ART. It is ART. So either it could be an IUI, that means an intrauterine insemination, which is allowed in level 1, and either it could be IVF, which is allowed in level 2. Now, if you have a person who is actually going in for an IVF cycle, that IVF cycle is going to happen in level 2. Now, a level 1 gynecologist who is not qualified as a level 2 gynecologist, she's just a level 1 postgraduate, has to take a level 2 along with her. So she has to register with a level 2, send her patient to the level 2, and the level 2 gynecologist will prescribe the medication or whatever is there. She can administer that medication that has been prescribed by the level 2, but she herself cannot prescribe anything for IVF. She is not allowed to prescribe because she is not eligible. Okay, she is eligible only for doing IUI. She is not eligible for IVF. So anything that she is doing beyond has to be done by a level 2 gynecologist.
Okay, thank you so much, ma'am. And it was absolutely
Thank you so much.
wonderful having you over with us. We will invite the next speaker for this session, Advocate Juhi Arora. Ma'am, over to you, please.
Thank you so much. Thank you so much.
Thank you, Ritima. And thank you, Sonia ma'am, for enlightening us with the full knowledge of the Act. I think you have not left anything to speak for me. You have almost covered each and every portion aspects of the Act and the surrogacy. And that is why we all salute to you, ma'am. You've been the icon for this. I'll try my I'll try my best to beat the little expectations of the audience over here. Anyways, since already ma'am has given much knowledge about the scenario and the regulations, everything about the Surrogacy Act, so I would only speak about the 5 pointers here. One is the eligibility, because that would touch the legal area of this act. Second is the procedure. What is the procedure? Third would be the appeal. The fourth would be the offenses and the penalty. And five, I would be touching some of the loopholes. So first, as we see, what is the eligibility if we talk about in this particular act, which states that there are three people which are affected. One is the surrogate mother. So surrogate mother eligibility is like the surrogate mother should be age of between 25 to 35 years. She should be a married lady. She should have a child of her own, and she should give her written consent, NOC, while undergoing the process, and she will not be given any commercial, like any monetary benefit out of this. Only medical charges will be provided to her. So these are the some conditions that are eligible, that only gives an eligibility once you predominate these conditions. So right now the point is that when we talk about the surrogate mothers, then in that case the woman who is having her own child and is of married in nature, and she should can only opt for once in a lifetime. The surrogacy she can go only for once in lifetime. She cannot go again and again, because see, the whole motto of this act is not for the commercial surrogacy. It's only to give an altruistic surrogacy in India. Then when we talk about the other person who is affected in this act is like the parent, that is the intended couple, or the intended person, that is called intended woman, or a person who is a widow, or any a female who is a divorcee can go for an intended parent to be a single parent. And when we talk about the parents' age, then in women it is 23 to 50, and for men it is 26 to 55. So this is the age, and they should not have their child. That's the first condition, that they should not have their own child. They should be childless couple, and it's that also that their marriage should sustain for at least 5 years. It means that they should have married long way back, 5 years back, and now they are coming ahead with the surrogacy. And basically, this is just to make believe that you have been trying in all those 5 years, because directly you cannot go ahead with the surrogacy. There is a condition that you should have failures some failures of your uh, normal pregnancy, some failures of your uterus is not there in the body, it has been removed, and some other medical conditions which are already written in the act. So that condition should be fulfilled, and then only you can go and opt for surrogacy. That is in the surrogacy regulations rules, uh, section 14 of this rules 2022. It is mentioned all the medical conditions which are which are intended female should have, then only she can opt for a surrogacy. Then it is also that the medical history. So this is the basically eligibility criteria for two people, that is the surrogate, the intended family. So now what would the effect on even on the child when the child is born out of this surrogacy? See, the child who is born out of this surrogacy will be considered as a biological child of the intended couple. Like, he would get all the rights in the properties, all the rights as biological child would have got if the parents would have given a birth to a normal child. So right now in this situation, child will have the proper rights and he can claim everything, and he would be treated and deemed as a biological child. Then the question which was just arising before the ma'am, that what would happen to those children who have been born out of this surrogacy after this act, the second children, the second or the third children who have been born out of the surrogacy, because right now after the act you can only avail the surrogacy when you have no child, but before it was not like that. So they were having, even parents who were having two child, then also they were opting for the third child in a surrogate manner. So that is the question. If this is arise, then in that case it is specifically mentioned that in after 2019, if any child is born before that, this act will not have any retrospective effect on on those children. So though they will be properly legal and a biological child concerned, and they will not have any illegitimacy to their effect. So this is the eligibility. Then second is the procedure. The procedure is that if the parents are um, who intended couple who wants to go ahead with the surrogacy, then they have to go through with the three procedure. That's a legal procedure. Apart from going before going into any treatment through a doctor with surrogacy, the first is that you have to get a certificate from a national board, state district board. Then you have to file a certificate application under section 4A of the Surrogacy Act. That application would be written application would be given to a district medical board, and then apart from that, the parenting order would have to be taken as per the section 4A second of the Surrogacy Regulations Act 2021, wherein the parenting order needs to be seek from the magistrate of of the jurisdiction, uh, concerned jurisdiction. And then third is the most important, which we have been taking care of, is that now the insurance coverage is necessary. That the surrogate mother should get an insurance of at least 36 months. And it is not that any Tom, Dick, Harry would get an insurance done. It has to be with the recognized agent of Insurance Regulatory and Development Authority established under the Insurance Regulatory and Development Authority Act. So that insurance company can only give the insurance coverage to these kind of surrogate ladies. Now, the point is that after these three procedures, then only you would be able to get a consent to go ahead with the treatment. This three long procedures, these three steps is now becoming very difficult. And in totality, that's very well said by ma'am, that it is execution and implementation is like very much difficult. I've been in a direct contact with the people sitting there, and they're even helping us out. It's not the way, because we have been filing some applications in the board, and we've been talking to the officers there. Even they have been hassled after getting so much inquiries and inquiries about that, how should we go, what should be the position, because if tomorrow you are filing any application and it get dismissed in some manner, then it will be very, because they've already very heartened and very uh, the couples are already very much in stress when they are going ahead with these kinds of process. And the kind of act in giving the statutory period and procedure is making more difficult. I think maybe tomorrow or maybe some coming years we will get some solution about it. So second is the procedure. Then I will be speaking that in case if your application is dismissed, and in case if your registration is being suspended of the banks, of the clinics, then what remedy you have? You have a remedy that you can go in an appeal that can be filed, and it is to be filed within 30 days of the that particular order of rejection, or the order of any suspension. If you have got, then you can go ahead with the appeal, and that appeal would be filed before the state board and then to the central board, so on. So you have an opportunity to file an appeal in case if you are aggrieved and against any impugned uh, suspension or the rejection order. Intended couples or the authorities, like who are doing who are having their banks registered, they can go and have can go for an appeal. That is the provision provided under section 14 of this Surrogacy Regulations Act 2021. Then the other portion which I would try to touch here, that is the offenses and the penalty, is that there are some proper reasoning being given in the act, which says that if you are doing any such offences which are mentioned in section 38 of the Surrogacy Regulations Act, that is called offences and penalties, that if you are issuing or publishing anything which is related to a commercial surrogacy, and if you're trying to get a sex selection in a surrogacy, and if you are abandoning or disowning the child which is born, or if you're exploiting the surrogate mother, or if you are undertaking any commercial surrogacy, in these kinds of if you are doing any kind of such offenses which are mentioned from A to G of the section 38 of the Regulations Surrogacy Act, then in that case you have to face the strict penalty punishments, which can run up to 10 lakh and to 10 years. So, and it is a cognizable and a non-bailable and non-compoundable offenses. So, in that case, we have to be very much concerned that, and apart from that, you also is that you have to follow the thumb rule of the surrogacy, is that it has to be a altruistic surrogacy. It has not to be any commercial activity or any commercial thing which can be involved in this. So, but the point is that if we have come to know that some authority or some bank or some clinic is undergoing such kind of activity, that is criminal activity of commercial, then what exactly the remedy we have? We can, any authority which is in central government or state authority can suo moto, can take an action against this kind of authorities. They can file an application before the court of an MM, and not inferior to the court of an MM. They can file an application, and that application can be filed under. And also, apart from that, any person, in case if any person is including any social organization, has come to know, then they can also issue a notice of not less than 15 days. So a notice has to be issued to particular authority or to particular banks, clinics, that the 15 days notice needs to be issued, and only then they can go with their application before the matrimonial magistrate. That has been mentioned in in section 44 of the Surrogacy Act clearly. So suo motu cognizance can also be taken by the central authority if they come to know that some uh, uh, some criminal activity or some illegal activities has been taken care in the banks and the clinics, so they can do that. Then the last I would say that what are the loopholes is basically is that first loopholes I would like to discuss is that that was right to privacy and against the reproductive right of a woman. So in that case, the center has just now cleared uh, in a Supreme Court plea that the child may not be needed genetically connection or genetically related to a surrogate mother. So that has been cleared by the center. Earlier it was not. So that was one of the loophole, because now it has been a specific notification which has been uh, given by the center in 3 months, 3 or 4 months back, which clarifies that the surrogate surrogacy can only be taken place if the intended couples are using their own gametes. So it means that they cannot have a donor, and it almost curtail or it almost cut down the rights or the privilege of those people who are actually cannot avail surrogacy because of not having any not having their own gametes. So it's now that you have to use your own gametes. It means that the sperm and the eggs of the intended couple should be of their own. They cannot use the donor. This is the recent notification, and somehow it is somehow been challenged in the Supreme Court also. Let's see what the result would come. And at times where some of the in some exceptional cases they might uh, accept the plea of a particular intended parents that they cannot have their own gametes, because there are various variety of medical conditions where the people are not having the even they are not able to produce their own eggs, or these sperms are not in good condition or good healthy condition. So in that case they cannot opt for surrogacy, and neither they have been left with any remedy even in the IVF also. So in that case, will they will be only having an option of an adopted parent being an adopted child? So that is again a question right now. So as of now, which is the current situation, they are only left with an adoption. What is the current situation? Maybe tomorrow we'll have some change, because this will take at least some time when new act come in the picture. It gives some time and it takes really difficult, because implementation execution it happens only with time. There are files which are pending before the district boards and needs the green signal to go ahead. Then the second is like loophole, which says that if you read the section 2S of the Surrogacy Act, which clearly says that the woman who is intending woman means an Indian woman who is a widow or a divorcee between age of 35 to 45 and who intends to avail the surrogacy. It means that a single woman can avail surrogacy. But what if single woman who is not married, here it only speaks about the widow and the divorcee. The act is silent upon the woman who is not married. So this is all to also have to be considered, and for this special plea has been already filed in the Supreme Court, and court has in fact filed and in fact issued the notice on this particular plea with the against the center to give a report on this particular section that says that only a woman who is married and divorced can go opt for surrogacy. Then the other is that the surrogate mother can be of age that is above cannot be of age of 30 above 35. Like as I mentioned before I started that the surrogate eligibility is the till 35 years, 25 to 35 years. So this is also a plea which is already pending in the Supreme Court, that what if any woman who is above 35 years and who is not married, because here also they have specifically mentioned the surrogate mother should be married and should have their own child of his one, the single child should be there. So what if any woman who is not married and who is above 35 is not eligible as per this act? So some kind of partiality or which really give a question rises to a Article 14 of Constitution. So this kind of plea is currently pending before the Supreme Court, and Supreme Court would be sooner or later would be resolving this problems and issues which is arising out of this act. So ultimately, at the end of the day, I would conclude by saying that surrogacy is totally altruistic surrogacy right now, and we have to follow some thumb rules. And still the picture needs to be cleared in the coming future, and we cannot right now say anything properly about the act. Whatever information we have got and gathered after attending so many webinars or trying to file the applications before the state board or district board, and speaking to the learned officers, the doctors, the learned doctors, then only we can gather. Because right now, as ma'am has correctly said, in Delhi, files have not been passed yet. So it is actually under the dark picture. So let us hope that in the coming months or the coming years, we will get a concrete solution to this. Thank you so much.
Thank you so much, ma'am. Thank you so much for covering all the intricacies so lucidly. So we'll directly jump into the questions. Um, the question says, for a couple who are eligible for surrogacy, but they do not have the option of going for altruistic surrogacy, what's the alternative to this?
See, as of now, there is no alternative. There has to be an altruistic surrogacy. You cannot have a commercial surrogacy. It's totally banned. And in fact, if you apart from this answer, I would like to add one thing more, that it has become more difficult for the OCI parents now. Now, earlier, parents who are intending couple who are the residents of India, they would have to follow the procedure which I have just mentioned. But the parents who are residing out of India, the Indian origin, but they are OCI, they would have to follow some more footpaths. And the other day, I was getting a consultation on the same surrogacy from a couple who was there in the London, and they were childless couple, and they were so much in a problem because they wanted to get it. The first thing which comes to a mind of an intending couple before going ahead with surrogacy is the simple first question is that how much time it would take. And we are actually uh, it's better to give a clear picture rather than putting them in a black and white situation. Is that time is time bound, we cannot suggest right now. It is totally not been able to uh, come up with a particular time कि हम time बता सके कि this is the timeline which will we get. So it is something which is not concrete right now.
Got it. Thank you, ma'am. So there's this question that was posed during Malik's ma'am session, so I'll try to repost it for you. The question was, what is the legitimacy of the second child born out of surrogacy, or where the intended parent or parents have a child out of surrogacy when they are not allowed or eligible, such as foreigners or
See,
LGBTQ
as I
or
told,
single men?
first of all, the LGBT community is not been allowed in this act. They have left them, and because of that, only the Supreme Court is running into lots of petitions related to equality and everything. But that has to be answered by the court only. I would not comment on that. But as far as the child are concerned, who was born out of this surrogacy, after this act, before this act, they are legitimate, and after this act, even that will not have any retrospective effect. So you have to see that whosoever have been born, because this act is has just started from 2019. But if they have procedure have been started, they cannot remove or they cannot do anything about that. But of course, after the act is formed, you cannot have the second child out of the surrogacy.
Very well, ma'am. So another question that we have for you is, supposing a woman has a child, but the child has gone to the husband after divorce, can she opt for surrogacy?
See, these kind of statements and these kind of questions are actually silent upon it. They are just saying that the child is you should have only, yeah, basically you should not have any child. You should be childless couple. But right now, if the child is not with you, maybe the child is in the custody of the husband. If she means to say that. after a matrimonial dispute. In that case, you can file an application before the state board, and you can you can ask for a plea. It's always there is a provision that you can ask for a plea or you can ask for a relief or remedy. But at the end of the day, it is a discretionary power, I would say. It is something which act is not giving here, and it is not clarifying. And on those points where the act is silent upon, you can always have a chance to take.
Got it, ma'am. Uh, okay, we have this last question for the session, which reads: how is the eligibility decided for a couple who is previously divorced and have a child, respectively, from their previous marriage with their ex-spouse? In furtherance to the same question, she is asking: the female has weak womb. Can the couple just hire a womb?
See, when we talk about the divorces, when you are talking about the divorces which is happening in the country, and after the divorces, you cannot go and opt for a surrogacy. So, of course, the same thumb rule will allow on you also that you should not have a child. Single women are allowed, single divorcees are allowed, single widows are allowed. But if you have a child of your own, you cannot allow that. You cannot opt for a surrogacy. So it is for them also. And since the same question is again repeated here, that if you are not having the child and child is in the custody, then in that case the other parent who is not having the child as of now, right now, because the child is in the other custody, you can always ask and you can always file an application to that respect. Maybe as per the discretionary power you might get, because in some or the other conditions there are always precedents are always made. Everything which is not in the act, then also the courts are setting their precedents. There are so many things like if we talk about the irretrievable breakdown of marriage, it is not a part of Hindu Marriage Act, but still the divorces are being granted on an irretrievable breakdown of marriage from the Supreme Court as a precedent. In fact, in my own judgment, I have got an my judgment has been reported in the DLT, wherein I have gotten divorce granted for my client on irretrievable breakdown of marriage way back in 2016. So it is some which is there is not an act. It says that you cannot have, that is not a current scenario. You can always apply and precedents are always set. So right now, if that is the situation, that if the parents, sorry, the couple is divorced in nature, then what they can do, and if the custody has been gone to that, then in that case you're always open to file an application, I would say.
Got it, got it. Ma'am, we have a rather very interesting comment which reads: maintaining a fetus up to born baby is a vital part of mother child bonding, and over time, it can infuse urge to feel some rights in the part of either surrogate mother or the one born by her towards each other. And this may reshape the preconditions like meeting rights or even care or voluntary or on demand. So, does the act cover this, or
Yes,
is there
yes.
a
Act totally covers this, that the surrogate mother will not ask for any, she cannot claim any right over the child. It clearly mentions it. And it is totally, it has to be written consent would be taken from the surrogate mother before going ahead with surrogacy procedure. So that has to be very much clear that she cannot claim any right over the child. So this has to be, the parents have to be fearless in this case.
We just received another question, and this is the last question for the session, which reads: using donor eggs, the child is born through IVF. Can the spouse claim that the mother doesn't have the right to the custody of the child in the event of divorce?
These kinds see, this is a medical conditions, and if the medical conditions cannot be taken consider while we are granting divorces or while we are granting the custody, it depends upon facts to facts. Not only a single condition of this medical condition, court cannot grant a custody to any parent. So you need to see, because see, I can understand biological parents are more concerned, and biological parents will have the first right over the custody of the child, then the natural guardian, and this go on. But ultimately there are so many facts, and there are judgments here in India which are now being pronounced, even being the mother also in the alive, since the even then also the custody have been referred to the father in many cases. So they are not considering the fact that while mother will have the first right, and by default the custody of the child would be till 7 years with the mother. So it's not the case right now. So it totally depends, I would say, upon the facts of the cases, and would also govern other parameters also.
Got it. Got it. Noted, ma'am. Um, okay, there was this a very interesting debate that started off when the Surrogacy Act was in, progress. So basically, it says that surrogacy is a serious infringement to the principle according to which the human body cannot be subject of contracts. So whether it's commercial or altruistic, does it not infringe the principal line of human trafficking or organ trafficking?
Can you please can you please read the question again?
So basically, the question says that does surrogacy in any way, be it commercial or altruistic, does it not infringe the already existing act which says that organ trafficking is prohibited? Or basically, is surrogacy as a whole procedure is in contravention to the Organ Trafficking Act?
I don't believe that it is actually contradicting, because here, when you are putting the gametes or embryos in the body of the surrogate mother, then in that case you are taking the consent. You are not doing it out of without any consent, and you this cannot comes under the trafficking, because otherwise also, and something which has not been forcefully done on you, and which has not been done under the impression or the force of coercion, this is something which is under the consent, under the agreement. So I don't think it is anywhere contradicting any other acts or in prohibition of any violation of any rights.
Got it, noted, ma'am. This is the last question posed to both the speakers here. I think Sonia ma'am is still around. So basically, you both have observed the whole surrogacy process very closely and being in touch with the surrogate mothers and everything. So, what is the condition of surrogate mothers and their own family during the whole process? I think they are put in hostels for the entire period. They cannot meet the family, child. There's a whole village in Gujarat, Anand, which is involved in this process, surrogacy. So, what are your thoughts on this?
Sonia ma'am would answer this, because
Okay,
she
all
being
right.
the doctor much more associated with those. I'm only associated with the intended couples.
Well, basically, again, like I said, every human being is different. So also doctors are different and situations are different. That is what we have to realize. And what has happened is that, taking a couple of examples which have been reported adversely in the press, has actually led to this impression that surrogates are treated badly. It's not like that. In fact, when you will see this film Dukan, which they have produced, it actually tells you of how well these women have done for themselves by doing surrogacy in Anand. They have got houses, they got money to build their own houses. They have got money to look after their children and educate their children. So it has been like a livelihood for them. I tell you, when we were not having donors and surrogates in Delhi, they were not available as such when I started my practice. I'm talking of early 2000s, when it was 2000 something. So at that time, I used to get calls from Gujarat saying, "Madam, मुझे इस महीने के लिए डोनर बना लो, मुझे मकान की किश्त देनी है." So basically, they were willing to do it because they were getting something out of it, and they were happy because they would have a better life. So these stories about surrogates being treated badly is actually, I haven't, but yes, they may be true, because basically you you can't say that everybody is the same, but that is happening in all professions. How are we looking at prostitution in this country? We know prostitution is not correct. It is not something which we should be talking about, and should be appreciated, I would say. But then prostitution is going from which level to which level? From the lowest level to the highest level. The highly, the high-end prostitutes, as I would say, or girls, are very well rewarded, and they are leading a beautiful life, wonderful life of their own. Whereas the one who is living in a small ghetto in one of the small areas, or mohallas of one of these small towns, is not leading the same life. So it's actually the disparity is happening socially over across all levels. Many a times we have actually wanted you people who are non-medicals to come and attend our clinics and see how the infertile couple is suffering. Somewhere, what has happened is that this whole act is lopsided. It is favoring the third party so much. The protection of the donor, the protection of the surrogate, even this act is mentioning very little about self cycles. There's hardly any mention. Most of it is third party reproduction, and that also the well being. Like I quoted that case, where the surrogate just refuses not to get anything done. Now look at the amount of paperwork, look at the amount of struggle and the harassment that the poor intending couple has gone through with the lawyers, with the board members, the money that they have spent. That is all wasted. Let alone the money that is spent in the clinic. All this has also happened, but nobody is bothering about that. So therefore, I think we should revise at looking at this more pragmatically. We must look at the surrogates, donors, as well as the self couples more pragmatically and see how we should balance this so that nobody is harmed. That is what I feel. But it is wrong really to say that every surrogate is ill treated. No, they are not. They are not. They are not. In fact, I remember in early days when people used to advertise for surrogates in Sarita and Hindus and Bharat Times, yeah. Manorma and Sarita, they used to advertise, and there was this couple who got a surrogate from Mumbai. She came with her three children and a surrogate. She came and they put her up in Mahipalpur in Delhi. They lived in Vasant Kunj, and every day that girl used to go and look after the children and the surrogate. And that woman was also very nice. The surrogate was very nice. So basically, they lived like sisters. And finally, she went back after giving birth to the child. She took her three children and went back. So it was purely commercial, but on a very, very nice humanitarian ground. That is what has to be encouraged. So, like I said, it needs to be strictly regulated, not throttled. You can't do this to the poor infertile couple. Where are they going to go?
Thank you so much, ma'am, and thank you so much, Juhi, ma'am, for your time. It was absolutely enriching to have you both on our platform. And I'm sure the all the participants who have joined us across the country have benefited from your session. We still have a lot of questions, so I request everybody to either mail it to us and we'll convey it to the speakers, your queries, and we'll try to get back to you with the answers. Thank you so much, and thank you to all the participants.
Thank you so much, Ritima. Thank you very much. Thank you very much.
Thank you so much, ma'am, for
Thank
making
you.
this to our participants, both of you. Your presence and sharing thoughts have greatly benefited to all of us and the participants as well. We will upload this video soon on the portal of this ASSOCHAM, that's YouTube channel, and other media's platform as well, for benefit of remaining participants who couldn't make it in this session as well.
Thank you
Thank
so
you very
much.
much for.
Thank you so much, Santosh.
Thank you,
Thank
sir.
you.
Thank you so much.
Thank you, Juhi. Thank you. It was wonderful.
Thank you,
Thank you
ma'am.
so much.
Same here.